Today, we're diving into a high-stakes corporate battle that went all the way to Singapore's highest court. And believe me, it completely redrew the map for how business disputes get settled. This is a story about a contract, a company, and a really fundamental question: where should justice actually happen?
So I want you to imagine this for a second. The business partnership you've poured everything into has gone completely south. And now your partner is suing you. But wait, you remember that your original contract says all disputes have to be handled privately through something called arbitration. So where does the fight happen? Out in the open for all the world to see, or behind closed doors? Well, that's the exact dilemma at the very heart of our story today.
Okay, so let's set the stage and meet the players. At the center of it all, we've got a minority shareholder, Silica Investors. They felt like they were getting a raw deal from the company's majority owners. The whole thing started when Silica bought their shares, and in that contract there was this tiny but crucial clause, an arbitration clause, and that little detail is what kicked off this massive legal battle.
So Silica went ahead and filed the lawsuit. The official legal claim was for minority oppression. Now, what does that actually mean? Well, in plain English, they were arguing that the people in charge were running the company in a way that was just fundamentally unfair to them. You know, the little guy. This wasn't just a simple disagreement. They were claiming the entire operation was stacked against their interest as shareholders.
Their case really boiled down to 4 specific accusations. First, they said a massive new batch of shares was suddenly created, which cut their own stake in the company by more than half. Poof, just like that. Second, they claimed they'd been promised a seat at the table, a role in management, and that promise was broken. And finally, the last 2 points were pretty serious. They alleged the company was basically being used as a personal piggy bank for the majority owner, guaranteeing loans and using company money to build up assets for totally separate businesses.
And here's where things get really interesting. The majority owners saw the lawsuit and immediately pointed back to that original contract. They said, hey, wait a minute, this doesn't belong in a public court. Our agreement says we have to arbitrate this. Silica, of course, disagreed. So suddenly, before anyone could even argue about the 4 allegations, they first had to fight about where to have the fight.
And this slide really lays out the 2 completely different worlds they were fighting over. A public court is exactly what it sounds like. It's public. Everything is on the record, a judge assigned by the state is in charge, and the decisions can have ripple effects for lots of people. Arbitration, on the other hand, is the total opposite. It's private, it's confidential, the parties actually get to pick their own judge, and the whole process is way more flexible. So you can see the stakes for choosing a path were incredibly high.
Now, this was not a simple problem. The whole mess landed right in the lap of Singapore's highest court, the Court of Appeal. And to solve it, they knew they couldn't just make a quick call. They had to untangle this complex legal knot by breaking it down into 3 core questions.
First up, arbitrability. The court had to ask, is a claim of minority oppression something that can even be decided in private, or does it touch on public interest so much that it absolutely has to be in a courtroom? Second, scope. Okay, even if it can be arbitrated, does the specific wording in this contract actually apply to these 4 complaints? And third, the trickiest one, overlap. What on earth do you do if the answer is yes for some claims and no for others? How do you possibly manage that kind of 2-front war?
So before even trying to answer those huge questions, the court did something really smart. It first established how it was going to approach the problem. It basically developed 2 innovative tools to build a clear framework for its final decision. The first tool they established is something called a prima facie review. The easiest way to think about it is like a quick spot check. The court's job isn't to do a deep forensic investigation into the arbitration agreement. No, its job is to just give it a quick at-first-glance look. If it seems valid on its face, the court steps back and lets the arbitrator take over. From there, the arbitrator gets to make the final call on their own authority to hear the case.
The second tool was all about perspective. They could have taken a broad view and looked at the whole thing as one big, messy fight over minority oppression. But they didn't. They chose a granular view. They decided to break the lawsuit down and look at each of the 4 allegations one by one, individually. And let me tell you, that decision to zoom in was an absolute game changer.
So, armed with these 2 new tools, the court was ready to deliver its landmark decision. And what they decided would end up setting a whole new precedent for business disputes.
So, on that first huge question of arbitrability, the court's answer was emphatic, a resounding yes. A dispute over minority oppression can be settled by private arbitration. This was a huge deal. It meant these kinds of fights aren't automatically a matter of public policy that have to be dragged into an open court. And here is the core of their reasoning, straight from the court itself. They said a shareholder fight like this is, at its heart, a contractual dispute. It's all about the commercial deal between the parties.
It doesn't really affect outside people like creditors or the general public in a way that demands a court's intervention. It is fundamentally a private fight.
So remember that granular approach we talked about? This is where it paid off big time. The court split the case right down the middle. It looked at the 4 allegations and said, okay, the 2 about the share issuance and the management role, those are directly tied to the original share sale agreement. So those 2 have to go to arbitration. But the other 2 allegations about the shady loan guarantees and using company assets, those had nothing to do with that specific contract, so they would stay in court.
Now, this wasn't just a win for one side or the other. This decision sent massive ripples across the entire business world. It provided a whole new level of clarity for shareholders, for companies, and for Singapore's legal system as a whole. So what does this all mean in the real world? Well, for shareholders, it's a crystal clear signal. That arbitration clause in your contract isn't just throwaway legal text. It has real teeth, and courts will enforce it. For companies, it offers a predictable and private way to handle messy internal fights without all the public drama. And for Singapore, this decision cements its reputation as one of the top places in the world to resolve complex business disputes. So when you step back and look at the big picture, what's the key takeaway here? It's that the law can be incredibly flexible and smart. By breaking a really complicated problem into smaller, manageable pieces, the court found this brilliant middle path. It upheld the private agreement where it was relevant while still protecting the public justice system for everything else. Just a perfect split.